Mr. Wolfenbarger, please. Day 8, I think, of the trial of Christopher Wolfenbarger. No, 9, 7, 9. Okay. Case number 24 SC 004201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that the state's counsel is also present. I am told that the wayward witness is here, Mr. McDermott.
Yes, Your Honor, I have made contact.
Has the state had an opportunity to make contact if they so chose?
We have not, and we don't need to.
Okay. Is that witness up?
Yes, Your Honor.
Is that witness in custody?
Yes, Your Honor.
Okay. My general understanding is that the Sheriff's Department prefers to have witnesses that are in custody to bring them in and have them placed on the stand rather than walk them through the courtroom. So if we could go ahead and do that and get the witness. Do we have any other matters while we're taking care of that we need to take up before we get the witness on the stand? Anything from the state?
Nothing from the state.
Anything from the defense?
Nothing from the defense.
Okay. Yes, sir. So just to be clear, Mr. McDermott, I'm still going to ask you to call your next witness, and then I'll just acknowledge that that witness is already on the stand, and then we'll swear them in as normal.
Do you want me to ask on the record permission to treat her as an adverse witness, or do you want me to make an attempt to get her to answer directly first?
I think she's your witness, so you should make an effort to see how cooperative she's going to be, and only if she's not cooperative would you then be justified in asking to treat her as such. Good morning. Ma'am, if you'll come over here to the witness stand. And she might need some assistance getting up onto the witness stand and situated in the chair. You could. Thank you very much. Okay. So we have our witness, and so I think we're ready for the jury, Deputy. Mr. McDermott, the defense may call its next witness.
The defense calls Wendy Wadell.
Okay. Ladies and gentlemen, as you can see, Ms. Wadell is already on the witness stand. Ms. Wadell, if you can, please raise your right hand to the best of your ability. The deputy will swear you in.
You swear affirm to the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Please state and spell your full name for the court, please.
Wendy, W-E-N-D-Y.
And if you could do me a favor and scoot up a little bit so I can hear you in the microphone.
And Wadell, W-A-D-D-E-L-L.
Thank you very much. Go ahead, Mr. McDermott.
Ms. Wadell, suffice it to say you don't want to be here. You need to answer audibly.
You're right.
Did you know Melissa Wolfenbarger?
I did.
And do you know the Patton family?
I do.
Carl and Norma? And how did you know them?
My parents grew up with them.
And did you live next door to them at one point?
As a child,
And were you at one point friends with Melissa?
I was.
Did you go over to her house frequently?
Every weekend. Every weekend.
Thank you. Do you remember something about their house that made you not want to go over there?
Yeah.
And what was that?
It smelled.
And why did it smell?
Well, people just have a smell.
What was the smell like?
Like a person that
Like
stinks.
body odor?
I mean, it wasn't nasty. She wasn't a nasty person.
Was it an offensive smell?
Any smell's an offensive smell.
Did you remember telling me?
Are you asking if she was a nasty person? She was not a nasty person.
I'm not asking if she was a nasty person.
Okay.
I'm just asking about facts. You remember speaking with me on the phone a couple of weeks ago?
Yeah.
And you remember telling me that the smell pervaded the house and
I did.
the car.
I got it on the car.
And
Got
it
it on
stuck
the
on everyone in the house.
It did.
Including Melissa. And you remember telling me that people bullied her for it,
They did.
picked on her. Do you remember telling me that Melissa had some kind of... It's not a leading question, Your Honor, unless it suggests an answer.
I'm going to overrule and allow it. Go ahead.
Do you remember telling me that Melissa had some sort of skin condition that caused her to have marks on her?
Contigo.
And it caused her to have visible marks on her body all the time?
Yep.
And how did you describe those marks? What did they look like?
Scratches.
Did you say bug bites, sores? Thank you. Can you remember how you described Melissa's personality to me?
Well, if I'd look back at it, I'd say autistic.
I'm sorry.
I said if I had to look back, I would say autistic. She
Okay.
would be autistic.
But you're not a doctor, right?
I'm not a
So you
doctor.
can't diagnose her with autism?
No.
But what made you arrive at the conclusion that she may have been autistic?
Just the way she is.
Let me describe those facts.
You know what an autistic person is. I mean, there's...
Was she quiet?
Sure.
Was she shy?
Yes,
Was she reserved?
she was.
Did she sometimes react?
She whined. She cried.
She whined and cried even when she was older. So are you suggesting she may have been a little bit
Of a baby.
infantile for her age?
Yeah.
Okay. You described to me a period of time in which you would visit her. Do you remember describing a time to me in which you would visit her almost every day
Every weekend, yeah.
and that you would be locked in the room with her?
Yeah, growing up.
And did you tell me that the door locks would be reversed
It
on
would
her
be.
door so that the lock was on the outside?
It was.
And do you remember that she was telling me that she was locked like that every day, all day?
Objection needed, Your Honor. He's giving the answers.
Overruled. Go ahead.
Do you remember telling me that she was locked that way every day, all day? I need an audible answer, I'm sorry.
Yes.
Thank you.
So was her sister. Her sister's right there.
And from what ages do you remember her being locked in the room?
I don't know, 12, 13.
Did you remember telling me it was started at about age 7,
I'm sure it started early.
went up to about 12?
Yeah.
Okay. You said her sister was locked too,
He's right there.
and she was locked up too? Mm-hmm. And
I'm sorry, was that a yes?
Yeah, my mom used to sneak over there and get her out of the window.
Thank you.
what's your mom's name?
Terry.
Terry Archer, is that correct? And
Is that a yes? You're
Yes, it
nodding.
is Terry Archer.
Thank you.
what was your father's name?
Bobby.
Bobby. And you said that your parents were wealthy
They are.
and that they paid to be involved in several activities with you.
They did.
What kind of activities?
GYOP. Georgia Youth on Parade. Girl Scouts.
You remember telling me that anything you did, Melissa
He
had to
did.
do,
That's right.
and that your mother paid for it. You remember telling me that looking back on the way she was treated, being locked in her room and being deprived. Well, let me back up. When you and Melissa were locked in the room, were you allowed to come out during the day? Were you allowed to get drinks of water?
Hang on. Yeah, you're shaking your head. Is that a no?
No, we weren't allowed to come out.
And were you allowed to get a drink of water?
Yeah, we can get. What was they were thirsty?
Okay. You remember telling me that looking back, you would consider that she had been abused and neglected.
Yes.
Today, if someone were treating their child like that, would you call defects?
Relevant, Your Honor. Objection, relevant.
Probably.
Hang on one second. Sustained. Go ahead.
Now, did you move away from Melissa's house at some point?
They moved away.
They moved away? Okay. And about what age were you at that point?
I don't know. I quit hanging out with them when I was 13.
Okay. And you told me a couple of events that happened with her before you quit hanging out with her.
She lost her virginity.
And how did that happen?
Objection, relevant.
Sustained.
Okay. May I approach, Your Honor?
Sure. Sustained. Move on, please.
Do you remember telling me that I caught myself? Was there a time that Melissa did drugs with you?
No.
Okay.
I was doing drugs.
Okay. And because you started to do drugs,
I
you
quit hanging
decided
out with her.
not to hang out with Melissa. You need to let me finish my question. I know it's kind of slow and tedious, but that's just for the record. You got to let me finish my question, and then you answer it. Okay. All right. Do you remember at some point Melissa started running away from home?
After I quit hanging out with her.
Okay. And do you remember that there was something that led up to her running away from home?
Her sister had a still baby.
Do you remember after Melissa was gone that she did not keep in contact with her mother?
I don't remember that.
Do you remember telling me that you don't remember her calling her mother? In fact,
Don't say that.
Okay.
How I know that?
And had you ever met Christopher Wolfenbarger?
Never.
No further questions, John.
Thank you. Ms. Hilton, questions for this witness?
Yes.
Oh, actually. Do you remember telling me that when you knew Melissa and hung out with her, that her mother would not let her have anything like makeup?
Is that a yes?
Yes.
Thank you.
And what did she do instead?
Use colored pencils.
Do you remember whether she was allowed to have feminine products?
Yeah.
You remember telling me on the phone that she had to use socks.
No.
If I showed you a transcript of our discussion, would that jog your memory?
Why would I say that?
Can I show you a transcript of our interview?
Sure. I never said that.
Would you like me to play the audio?
Sure. I must have been high.
Permission to share, Your Honor? Permission to share, Your Honor?
Granted, just make sure that what you're going to share is only the portion that is relevant to the question you've just asked.
I can imagine she was traumatized.
She was traumatized. She was. And let me tell you, like, makeup, when she would put makeup on, she would have to use color pencils because her mama did not give her those things.
Oh.
You know, like she, you know, would have to use, I hate to say it, but like socks for pads and shit like that. You know, because her mama neglected.
I guess I did say that. That was her.
No further questions, Your Honor.
Thank you. Ms. Hilton?
Good morning, Ms. Wadell. How are you?
Withdrawing.
Withdrawing. Okay, but you answered his questions. Have you and I ever met? Is that a no for the record?
No.
And have we ever talked on the phone?
No.
Okay. And you spoke with Mr. McDermott a few weeks ago over the phone? Is that a yes?
Mistake. I thought it was you.
Oh, no problem.
But go ahead.
But you talked to him about a lot of different things. Is that fair to say?
Yes.
Okay. And so you were her next door neighbor, correct? Melissa's next door neighbor.
As a child.
And as a child, that from between the ages of 7 and 13?
No.
What were the ages?
Ages of 2 to 7.
2 to 7. Okay. And your parents are friends or were friends with Melissa?
Our friends.
And you said you spend time at her home every weekend, correct?
Did.
And you just testified that there was an odor in the home that you didn't like. Is that fair?
So yes.
Yes.
Thank you.
But every weekend you would still go to the house.
Yes, I love them.
And I think you testified earlier that your mom would have to take Tina out the window.
She would.
Okay. But your mom still let you go over there every weekend.
She did.
Now, you said that Melissa was able to do Girl Scouts with you. I think you told defense counsel over the phone cheerleading, and then you just said like a girl youth group. Is that the third thing you just said?
Something like that.
Right. And it's safe to say that her mother will let her go with you
For
to
sure.
do these events. Right. Although your family paid for it, her mom let her participate in those activities.
She would.
And that kept you all busy. Is that fair to say?
It did.
That's a lot of activities, right? Now, at some point, is it fair to say that your mom moved to Covington and you moved to Covington?
I did.
About how old were you when you moved to Covington?
13.
And Melissa would still visit you while you were in Covington.
She did.
And so her mother would let her leave from Stockbridge. Is that a yes?
McDonough.
From McDonough and come see you in Covington.
She would.
How far is that?
30 minutes.
So it's safe to say Melissa would have to come out of the room in order to come see you. Is that fair?
No, she didn't lock her in the room like at that age.
Okay. Now, when you all were younger, did you tell defense counsel that you all never knew what Carl Patton had done?
Never.
You did not know?
We didn't. Not until they came and got him.
And when you said when they came and got him, are you talking about you found out in 2003?
I'm talking not until the police came and got him.
Okay. Now, is it fair to say that the last time you saw Melissa was in 1997?
Last time I saw Melissa would be about 1998, 97.
97, 98. And I'm sorry, did your family have like an event every year and the
They did.
Pattons would attend?
Yes.
What type of event was that?
Holidays.
And you talked about Melissa's kind of demeanor. In your opinion of knowing Melissa, would she ever just leave her children?
No.
Would she ever just stop talking to her children?
No. Not that I'm aware of.
Now, when you spoke to Mr. McDermott, you described Melissa as not bright at times.
No.
No, you didn't, or no, she
Yes.
wasn't? I'm sorry.
Yes, she's not right.
Okay. That she was easy to control?
She was.
You said that she was weak?
She was.
You said that she was submissive?
She was.
You described her as a type that would not fight.
She don't.
That she was very naive.
She was.
Not a smart thinker.
Not a smart thinker.
You said that she's dependent on whoever she is with.
That's right.
That she would not be the leader in a relationship.
She would be.
Matter of fact, in your friendship, she kind of follows you.
She did.
And you said kind of after you left, Melissa had no friends.
Right.
Now, I know you just told defense counsel that you never saw Mr. Wolfenbarger, but you had the occasion to speak to him one time on the phone.
Well, I guess very short, he would let me talk to Melissa.
Tell the jury about that.
He just wouldn't let me talk to her.
When was it?
In 97, 98.
Do you recall telling Mr. McDermott that was around Thanksgiving in 1998?
Something like that.
And that you actually called to speak to Melissa on the phone?
I did.
And Chris answered the phone,
He did.
and he wouldn't let you speak to
He
her.
wouldn't.
And he was controlling her ability to talk to you.
He was.
And it's fair to say that at that call, he did not want Melissa to talk to one of her childhood friends.
Objection.
Sustained.
It's true.
When if there's an objection and I sustain it, you have to not answer the question,
Sorry.
okay? Thank you.
And was that the only time that you talked to Chris in Thanksgiving of 1998?
Yes.
Court's indulgent.
Sure.
No further
Hey,
questions.
thank you. Mr. McDermott, any additional questions?
Yes, ma'am.
You just told the state counsel that when you talked to me on the phone, you thought it was them.
I did.
Is that correct? And didn't I tell you on the phone, I'm Christopher's attorney?
No. He said defense.
Okay. Permission to play some audio, Your Honor?
She said you said defense.
Okay. So I did tell you.
Just making sure you heard her answer.
I did tell you I was the defense attorney.
You did.
Correct. And then I told you I'm Christopher's
You
attorney.
did tell me that.
Okay, thank you.
Afterwards, yes.
At the very beginning of the conversation.
Look, I get high every day. I do drugs. So I'm just trying to tell you, I don't know, what I say. And I hate to burst your little bubble. I'm just telling you, I do heroin every day. And I'm going through withdrawals. And that's the whole point I didn't want to come here. So I don't know what this would be.
Were you on heroin when you talked to me on the
was.
phone? You're on heroin right now?
Only because I'm locked up. Sweating to death.
Just to reiterate, you quit hanging out with Melissa around age 13, correct?
I did.
So you had really not much interaction with her after that.
I didn't.
Okay. So you don't know what she was thinking or doing after that age?
No.
Okay. No further questions, Your Honor.
Thank you. Ms. Hilton, anything else?
In that Thanksgiving 98 call that we just talked about, do you recall telling defense counsel that the Pattons were at your family's house for a family function? Is that a yes?
Yes.
And that it was during that family function you asked about
Her.
Melissa, and you said, give me a number so I can call her.
I did.
No further questions.
Mr. McDermott?
No further questions, Your Honor.
Okay. Ladies and gentlemen, just for some logistics, I'm going to have to ask you to step out for just a moment, and I'll have you right back as quick as I can. The jury's clear. You may be seated. Deputies, if you'll assist Ms. Wadell, she's excused as a witness. Yes, Your Honor. Thank you, Ms. Wadell. I was just going to say I trust that her release will be processed as quickly as possible. Mr. So I understand what's going to happen when I call the jury back in. Does the defense have any other witnesses, or is the defense planning to rest?
Defense rest, Your Honor.
Okay, well, I'm going to need you to do it formally in front of the jury. I'm just asking in advance. Does the state still have planned rebuttal?
Yes, we have 2 witnesses for rebuttal.
Okay, and do you have them ready to go outside the door?
One is right outside the door, and the other is our DA investigator.
Okay.
He's sitting right here.
Okay. Okay, so we're ready for the jury to come back in then, and we'll have the DA rest, and, or excuse me, the state will rest, and the DA can take up its rebuttal. Is that a yes, Ms. Hilton?
Yes.
Okay, is that a yes, Mr. McDermott?
I'm sorry, Your Honor. Question?
Okay.
Question again, please.
Are you ready for us to come in and proceed in the manner I indicated, which is that y'all are going to rest once the jury comes back in and the state's going to take up its rebuttal?
Yes, Your Honor.
Thank you. Please be seated. Mr. McDermott, the defense may call its next witness.
Your Honor, the defense rests.
Thank you. Ms. Hilton, any rebuttal from the state?
Yes, Your Honor, briefly. The state will call Detective A.B. Calhoun.
Okay. If you'll coming up to the witness stand, and before you, once you get there, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
You swear upon this testimony that you're about to give the truth, the whole truth, and nothing but the truth, so you got to see.
Just be careful of that ledge, and then scoot up to the microphone and state and spell your name for the record, please, sir.
My name is Alton, middle initial B, Calhoun, A-L-T-O-N, again, B, C-A-L-H-O-U-N.
And good morning, Detective Calhoun. How are you?
I'm doing fine.
I want to direct your attention specifically to April 7th of 2003. Did you have the occasion on that day to speak with Kimberly Cameron?
Yes, I did.
And how did you make contact with Ms. Cameron?
I made contact with her, phone contact with her.
And who, at the time, did you know who she was?
I knew that this was a very close friend, a very close friend of Melissa Wolfenbarger, and also Chris's Wolfenbarger's sister.
And did you speak with her on that day over the telephone?
Yes, ma'am, I did.
And what, if anything, let me ask you specifically, was she able to tell you about her relationship with Melissa?
Yes, ma'am.
And was she able to tell you about Melissa's feelings towards her brother?
She shared that, yes, she was.
What would she tell you?
She shared that they had problems as a couple, like everyone else. Sometimes they had problems.
Did Melissa ever tell you did Kimberly ever tell you if Melissa was planning on leaving her brother?
Yes, ma'am, she did.
What did she say?
She said that we were speaking and she indicated that in a conversation that she had with Melissa, Melissa expressed her love for her brother, but while she loved her brother, that she was planning on leaving him.
And did Kimberly ever indicate that Melissa wrote her a letter?
Yes, ma'am, she did.
Did she still have the letter?
I don't know. I asked her about, when we were doing the interview, details, if this was based on something from the letter, so I don't know where the letter may be.
And after speaking with her on the telephone, did you have the occasion to try to meet with her in person?
Yes, and I'll say that the telephone conversation was, the purpose of that was to set up a time that we could come meet, and I can interview her more in detail.
And did you eventually meet with her?
Yes, ma'am, I did.
And when did you meet with her?
Well, that was April 23rd.
And when you met with her, was there anyone else present with her?
Yes, ma'am, there was.
Who was present?
Her mother, Kathy Wolfenbarger.
And during that meeting, were you able to speak with Kimberly by herself?
No, ma'am.
Why not?
When I got there, of course, I met Kimberly, and I saw that Mrs. Wolfenbarger was there and learned who she was, and I told her that I would like to speak with Miss Kathy as well, but it was my intention to interview her, Kim, and then speak with her mother, and that I would like it. It'd be nice if her mother was to be able to leave, but Kathy made it very clear, I should say, that she was not going to leave. She was going to stay there with her daughter at the interview. So at that point, I had no other choice but to interview them together.
And where did you go to conduct the interview?
I went to Kim's home.
So this is at Kim's house?
This was at her house, yes, ma'am.
All right. I have no further questions.
Mr. McDermott?
Mr. Calhoun, you interviewed a lot of people during this investigation around that time, correct?
Yes, sir.
You interviewed Christopher, didn't you?
Yes, sir, I did.
And do you remember making an audio
Yes.
version of that interview?
Yes.
Do you remember interviewing Don Perone,
Yes.
the neighbor down the street?
Yes.
Do you remember Don telling you he drives a hearse?
Objection, hearsay.
Sustained.
You made an audio recording of that interview, correct?
Yes.
Okay. And you interviewed several other people. You made audio interviews of them.
Yes.
And we have something like 6 audio files that you created.
I'm not sure the number.
Does that sound roughly correct?
That sounds like that.
Okay. And for this discussion with Ms. Cameron, did you audio record that?
Which the initial phone interview?
The one you just testified about right here.
I believe I did. I'm not sure. All the interviews were there. If I recorded an interview, it was in the file, but there were some times where I just wrote things down from my notes.
So if there's no audio in the file, then you didn't do one?
There was no recorded interview. I just went on the notes from that interview. Yes, sir.
So what you testifying here today from the notes you wrote?
Excuse me?
Are you testifying here today from the notes you took on that interview?
Yes. And when I say notes, the notes that I did, the way it happened is, as investigators do, we have notes, a notepad, and you'll just write notes throughout, over the course of the investigation. I then at some time take those notes and transcribe those to the report.
Okay. Do you mind if I see your report?
Yes. Those would be the 2 pages from that time frame.
So those are not recording anyone's exact words, correct?
No, I just gave a brief synopsis. If you read these notes, you'll see there was just a synopsis of what they said to me.
Okay. And we have no way to check to verify if that's what she actually said.
What's that? Who's that? I'm not sure who you're talking
So
about.
you interviewed Kimberly, correct?
Yes.
And all we have from that interview is your written notes on it.
Yes.
So we have no way to verify that that's what she actually said to you.
I guess that would be correct.
Okay. No further questions.
Ms. Hilton?
Did you have any reason to make up what your conversation was with Miss Kimberly Cameron?
No, ma'am. This was something that I had no reason to make anything up.
Thank you. No further questions.
Mr. McDermott?
No further questions.
Okay, thank you, sir. You may step down.
Thank you, ma'am.
Ms. Hilton, state may call its next witness.
Yes, Your Honor. The state calls Andre Curitan to the stand.
Thank you, sir. Do me a favor, come up to the witness stand. When you reach the witness stand before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
May we approach?
Yes? Swear in the witness.
You swear or affirm to the testimony that you're about to give the truth, the whole truth, and nothing but the truth, so you may have a seat. Please state and spell your full name for the court, please.
First name is Andre, A-N-D-R-E. Last name is Curitan, C-U-R-E-T-O-N.
And where do you work?
Fulton County District Attorney's Office.
And what do you do for the Fulton County District Attorney's Office?
I'm a senior investigator.
And just describe briefly some of your job duties as a senior investigator.
We mostly, we're assigned to attorneys. Anything they need, any evidence to be picked up, we subpoena witnesses and sit with our attorneys as they interview the victims or witnesses.
And are you also required to sit in the trial of those attorneys as a trial may proceed?
Yes.
And have you been sitting in this courtroom for the duration of this trial as it's been proceeding?
Yes.
Right. Now, as a part of your responsibility, you said that you have to meet with witnesses with the attorneys.
Yes.
Okay. Do you recall ever meeting with a Norma Patton?
Yes.
Okay. And when you met with Norma Patton, do you recall her ever providing to the state letters and cards?
Yes.
What did it happen with those letters and cards that she provided to us?
She provided to them. No, we made copies of them. Or legal assistants made copies of them, so we could have.
And so did she bring originals and our legal assistant in the office made copies of those originals?
Yes.
And I'm going to show you what's been admitted as Exhibit 67, 68, 69, 70, and 71. Are these some of the letters and cards that Ms. Patton provided that we made copies of?
Yes, these are some of the ones she brought in.
And that we made copies of?
Yes.
Thank you. No further questions.
Mr. McDermott?
I have no questions for this witness, Your Honor.
Okay, thank you, sir. You may step down.
Thank you.
Ms. Hilton, state may call its next witness.
Your Honor, the state has no further witnesses. The state rests.
Mr. McDermott?
No further witnesses, Your Honor.
Okay. Okay, so that means the evidence in this case is closed. Ladies and gentlemen, there are a few things that we have to take up to get ready for closing arguments and the final jury instruction before you begin your deliberations. And so it's about 10:20. I'm going to excuse you. I'm guessing conservatively about 20 minutes. I'm hopeful that we'll be back in here around 11 just to give you a target for what to aim for. But for now, you are excused. We'll have you back as quick as possible. Thank you.
All right, for the jury.
You may be seated. So we need to revisit some matters that we were dealing with yesterday in order to finalize jury charges. Are there any matters other than those? Are there any matters the parties want to bring to the court's attention that we need to address?
I don't think we have any.
No?
Nothing from the defense.
Okay. So so I have sort of a bullet point list of things that I was supposed to do homework on last night. I have, and so let me address a couple of things. Number one, I have looked at the request from the defense to provide a charge on immunity of witness. I think that the better course here is to not give it. It's not directly implicated by the facts of this case, and the defense doesn't need it to make the argument that it wants to make. And so I'm not going to give the immunity charge 13180. Mr. McDermott, you asked me to adjust the circumstantial evidence charge to change the word theory to the word hypothesis. I'm not going to do that. The pattern is the pattern, and I believe the pattern is there because theory is a more accessible plain language word than hypothesis is, and that's why it's been changed. And so we're going to stick with the pattern. Excuse me, sorry. I'm not going to give the prior difficulties charge. And that, as I consider it legally, I think there is a conflict I cannot find case law, and if you can point me to some, I would appreciate it. But I cannot find case law that distinguishes between the fact that prior difficulties, there's tons of case law that talks about the fact that prior difficulties are likely for intrinsic evidence, right? There's secondary sources and there's cases that say that prior difficulties is likely intrinsic, et cetera. But what I can't find is case law that reconciles this tension between the fact that if the court has ruled, which it has here, this evidence of the dealings between Mr. Wolfenbarger and the victim is intrinsic to the case, then I think that the evidentiary standard is very clear that that evidence can be considered for any purpose. And prior difficulties evidence would be the charge that's been requested by the defense is what would apply to evidence that wasn't otherwise intrinsic, but that was allowed as a prior difficulty. And because I've allowed it as right, wrong, or otherwise, because I've allowed it as intrinsic evidence, the jury can consider it for any purpose. And I think that instructing them on prior difficulty would confuse the jury about what the standard is that they are to apply. And so I'm not going to give it. The last issue is really two issues, which is I took under advisement the motion for directed verdict of acquittal on count 2 for felony murder, and obviously the associated jury charge that goes with that. If I grant the DV, then I wouldn't give those charges. I spent a good bit of time with this last night, and while I agree again with the state that there is evidence here from which either facts or reasonable inferences from which a reasonable finder of fact could determine that a homicide occurred and or that Mr. Wolfenbarger may have committed it, I do not believe that there are facts from which a reasonable fact finder could even make a reasonable inference that a weapon was used or what kind of weapon was used. And because of that, I don't believe that I don't believe that there are facts from which the state could present the count 2 felony murder, which requires that showing of aggravated assault. And so I'm going to grant the defense's motion for directed verdict on count 2 of the indictment for felony murder, which means that I would not give those charges. It means that the jury, I need to amend the verdict form to include the sole count of the indictment for murder, We also need a redacted indictment reflecting only that one count of felony murder. What record would anybody like to make regarding that ruling? Mr. Wilson, you're standing.
I would, Your Honor, and
Yes, sir.
I'd like you to reconsider it in light of. I did look for some case law, and I thought what would be very helpful to everybody is case law where a murder occurred where either the body was never found or there was decomposition. They couldn't determine the exact cause of death based on advanced decomposition. And what I found was Richardson versus State, and the site on that is 278 Georgia 548, and it says that if there is evidence of an act, the jury can, and remember we're dealing with the standards for directed verdict, whether there's a reasonable path for a reasonable jury to follow the state of facts. And Your Honor, I do think that also on Courier versus State, which is the site is 294 GA 392. This was a case where there was, I mean, it's very similar to our case in that the remains of the victim were subject to decomposition, and the medical examiner gave an almost identical cause of death, which is undetermined homicidal violence. And that's what we had from Dr. Terry.
Right.
And that was acceptable, and I believe, and that's actually a felony murder case, Your Honor, predicated on aggravated assault, where there was a non-specific form of aggravated assault. The court said that there had to be some evidence, and I'm going to get there really quick, Your Honor, and I do believe that the court has evidence, and the jury has evidence. As the court said before, the court was going to consider the prior acts of the defendant to the victim as intrinsic evidence. I think that's critical to the analysis on whether, and this is, like I said, this is a directed verdict standard. It is critical when the court makes that ruling that this jury can infer from the fact that he's done it to her in any indeterminate manner before, he'll do it to her, he could do it to her again. I think that's a completely reasonable assumption. And that's what the case law says. They can consider it for any purpose that they choose, Your Honor. So I think that because it's intrinsic evidence that there has been past domestic violence, you've got that. That's the big thing. You've also got the medical examiner saying undetermined homicidal violence. You've also got Rosa James saying, educating the jury on this cycle of violence and what happens. Your Honor, there is a path, and I understand where the court was coming from. But I think when you allow intrinsic evidence that can be used for any purpose, that's what the question is on a directed verdict. It's not whether or not it has to happen, whether it's possible that it could happen. And I think a jury can take that evidence of the prior assault and say, you know what? Given the escalating type of violence, this is now an aggravated assault. And this is why she died. And that would bring it in directly with the case law. So that's our argument. Your Honor, I think the court should reconsider its motion, or its ruling on the motion, and allow this case to go to the jury, because I think there is evidence. And I know the court was struggling with that extra evidence, but it's there.
A couple of questions. One, I was able to pull up the Courier case. I'm not, the first case you gave me, I don't know if I've typed it in wrong or wrote it down wrong. Can you give me that site again?
Sure can. It's 276.
Wait, say it again?
276.
276.
That's what, I think we all wrote down 278, or at least that's what I wrote down. 276 Georgia 548?
Yes, ma'am.
Thank you. I will tell you, one of the reasons that I wanted to make sure I had the right citation for that case is that my brief review of the Courier versus State case is it would be distinguishable because I think in that case there was direct evidence of some sort of scuffle between the alleged perpetrator and the victim prior to the victim then later being found dismembered and in a decomposed state, which is evidence from which a jury could find that aggravated assault, of which there was evidence, caused the death. I mean, I read that case very briefly to be more about proximate causation than about whether there was evidence of an aggravated assault, because it sounds like there was.
Well, and I think when you, like I said, when you allow intrinsic evidence, is there a path? That's the thing. Is there a path for a reasonable jury to conclude that the violence escalated and this defendant committed an aggravated assault? I think it's relatively settled that the manner of aggravated assault is not really the relevant factor. Is there evidence? And I think Richardson talks at that, and I think Currier does too. But I think with the intrinsic evidence of past violence and the fact that the jury could consider that for any purpose they want to, and given the standards on a directed verdict, could they do it? Absolutely, Your Honor. That's our position. So I'd ask that you reconsider.
Okay. I appreciate that argument. First paragraph of Richardson says that there were bloodstains found on the victim's bedroom ceiling and walls that were evidence of the infliction of severe blunt force trauma. That's, again, factual evidence from which a jury could make a reasonable inference. What we have here is a history, right, between the defendant and the victim, but no direct evidence of a particular interaction between the two of them that could constitute an aggravated assault. And more specifically, there's no evidence from which a jury could infer the presence of an dangerous instrumentality or offensive weapon. And that's really, to me, the deciding reason. I understand the state's theory, but I still don't think that there are facts or reasonable inferences that can be drawn from those facts, from which a jury would be justified in determining that an offensive weapon existed and or that an aggravated assault occurred. There is evidence from which a jury could infer and determine that a homicide occurred, and so that's why I've ruled the way I have. I understand the state's objection. Is there any further record that you would like to make on that point, Mr. Wilson?
I don't believe so, Your Honor.
Okay, thank you.
Your
Anything
Honor, I'd
further
also
defense?
point out that Richardson's a malice murder case. It's exactly what you're holding in this case. There's sufficient evidence for malice murder.
Okay. Anything from the defense? Okay. So it is 10:40. What I need to do is I'm going to, as I said, edit the verdict form. I'm going to email y'all in just a moment. I'll probably have my staff print a final, or more final, unless y'all tell me there's something else to address, version of the jury charges. Is the state in a position, because y'all have, my understanding is it's easier for y'all to print a version that's whited out of this. I can have my staff get rid of count 2 in both places if you want me to, but since the indictment goes back with the jury, they need a clean version of it with just that one count. Okay? Okay. It is 10:40. My goal is to be back in here at 11 with everyone's final approval of the verdict form and the jury charge, and then ready to start with closing arguments. Is that good with everybody? Mr. Fawcett?
Yes, sir.
Mr. McDermott?
Yes, Your Honor.
Okay, we're in recess until 11. And yeah, okay. Okay, Madam Court Reporter, you ready?
Yes.
Okay, so Mr. Wolfenbarger is back in the room. I have provided the lawyers with a newer version of the verdict form that is only count 1 for murder. The state has provided me, and Mr. McDermott has had an opportunity to review a redacted version of the indictment that only charges the 1 count of murder. I've also provided the lawyers with the jury charges that I have redacted and tailored further to the evidence in this case to remove references to the 2nd count of the indictment and to remove For example, like I usually have a pattern that says, there's a multi-count indictment, so I've removed that. And wait, I just realized I missed one. I need to remove prior difficulties, which I advise the parties I would not be giving. So if y'all could please make a note, I'm removing it from the version that's going to go to the jury, and I'm removing it from the PowerPoint that will be displayed. But if y'all could please mark that out in your packets. And I believe that now that I have removed the prior difficulties charges, I indicated I would not give it. I believe that the version that I have provided you accurately reflects the rulings that the court has made in terms of what the court intends to give or not. If you've had a chance to look at it, any objections to the charge that the court intends to give from the state?
No, yeah.
Mr. McDermott for Mr. Samuel from the defense?
Well, we wanted prior difficulties.
Yes, sir.
We wanted 404B.
Yes, sir.
Do you need us to renew our objections after the charge, or is this the only time to preserve?
So what I was expecting, other than preserving the objections you've already made, do you have any additional objections to the charge that the court intends to give?
No.
Okay. And then after I give it, I will give you an opportunity to say that you object to the charge as I gave it.
Right.
Okay. And then the verdict form, which is just the one count. Does anybody have any objection to the verdict form?
No, yeah.
Okay. So what I'm going to do in just a moment then is bring the jury in. And just so you know, I will provide the jury with one copy of the jury charge, the verdict form, and the redacted indictment. That will go on top of whatever evidence the parties agree is going back with the jury, subject to any continuing witness or other objections the parties may have. I know we have one, just to flag it for everybody's memory, Exhibit 30A is a redacted version of I think, audio recording, and we're in agreement that 30 is in evidence but would not go back. It's 30A that would be played for the jury if they wish to see it. Beyond that, I will rely on the lawyers to tell me if there's any additional evidence that is in evidence but should not go back with the jury. Anything else before I call the jury and then we get started with closings? From the state?
No, Your Honor.
From the defense?
No, Your Honor.
Okay. Do you have a PowerPoint?
I do. Yes,
Okay. Are you logged in and ready to go with it?
I am.
Okay. You can go ahead since I'm going to go straight into, well, I take that back. Are you going to open and close, Mr. Fawcett?
No, just to open.
Is the state going to open and close?
Start it out.
Right. Okay, so since the state is going to open and close, you can go ahead and have your PowerPoint up and ready to go on the screen. We're ready for the jury.
What time do you plan to take a break?
I've ordered lunch for the jurors at 1:30, and so my plan is to see if we can target being done at 1:30 or shortly before, but if we can't, then we'll keep going unless the jury says they need a break. focus on the closing arguments and the jury charge when I give it to the jury, and so I'll ask that you not go in and out, and if you absolutely have to go out, if you'll please do so as quietly and non-disruptively as possible. Thank you.